This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
31 breach. A breach is, I suppose it's a fancy word for break. A breach is a break. Somebody breaks a term of the contract. And the breach of a contract may be by the one who's breaking the contract. They may say before the time the contract is due to start, they may give notice and say, I'm not going to go ahead with the contract. Now I think I may be right that over here, if you choose to enter into an agreement and then say, I'm not going to go ahead with it, the other person says, oh, all right then, and that's it. Am I right? Yeah. If I'm in a contract and I've got to perform a service for you on the 4th of April, and you tell me that you're going to break the contract, I say, okay, pay me the money that you would have paid me. Now, I don't think that happens here, but in the UK, if I'm in a contract which is due to start in the future, and you break it, then I can claim all the money that I was due to receive under that contract. Say me again? You can negotiate and try to make a settlement, but if I'm feeling upset with you, I'm going to say, no, give me the full money. Give me everything that you owe me. So that is where you give or receive notification that the contract is not going to go ahead, and that notification is in advance of the time that the contract is due to start. And that's called anticipatory breach. It's a breaching notice which is given in anticipation of the contract beginning. We had that, didn't we? We had that with an opera singer. Which was the case where it was anticipatory breach? In fact, they were both anticipatory breach. What was the name? What's for French for push? Be careful. Poussard. Poussard. And the other party was Spears and Pond. And what was the name of our Italian centre forward in 1974? Bettini. And who was the other guy? A Bettinian guy. Okay. So those were both examples of anticipatory breach, notification that they're not going to go ahead with the contract according to the original contract terms. Terms, of course, can be subdivided into two, can't they? What's the subdivision of terms in a contract? They may be either, or they may be the big one, the important one, the one which gives rise to the end of the contract is a term which is called a condition, whereas one which is superficial to the contract, that's a term which is called a warranty. And sometimes there's a term that we don't know what it is until it's broken, and that's called that's an innominate term. It has no name. Remember the French word for name. It has no name. It's an innominate. It has no name. Okay. Maybe during or maybe anticipatory. I've already given you these two examples of anticipatory, but I'm talking here to begin with about during. For instance, if I say to John, I'm not doing any more, I'm fed up. I'm just going to walk out now, and that's it. Then it's a breach during performance. I'm engaged, my services have been engaged for 3 days. Partway through the 3 days I say, I've had enough, I'm leaving. That will be breach during performance. And the injured party can then treat the contract as discharged if it's a breach of condition, and they sue for damages immediately. They can claim the damages immediately. You see, if I walk out, not only am I breaking my contract with John, but in addition, John is then being put into the position of breaking his contracts with you. Because he's in contract with you to provide you with 3 days' worth of excitement, and if I walk out, then the excitement stops. So he's in breach of contract with you, so you sue him because he's broken your contract. Equally, he will then sue me for all the loss that he's had to pay you, because those are the damages which he has suffered. Anticipatory, one party gives notice before the contract is due to start that they're not going to go ahead, and in that situation the injured party again can sue immediately and get the full amount that they would have received if the contract had gone ahead. And we've got this case Hawkster and Dill. This is about a student who one year he was invited and entered into a contract to act as a tour guide. So taking tours of visitors and guiding them around the city and showing them the different monument, the Brevibas monument, which the tourists will probably then use in the way that tourists do use your Brevibas monument. So the tour guide was showing these people around, and then the next year the tour company contacted him again in April and said, "You're near the end of your university year. We'd like to have your services again for this summer to take the tours around your city." And he said, "Yes, okay," and the terms were the same, the amount of pay was going to be the same. And then in May, they contacted him again and said, "Sorry about this, but we don't actually have any tourists who want to go there this year, so we're going to have to relinquish, we're going to have to give up your services for this year. Sorry about that." And he wrote back and said, "Well, I'm sorry as well, but you can still send me the money that I would have earned if our contract had gone ahead." And they said, "But you haven't done anything, and therefore we're not going to pay you any money." And it went to court, and the court said it's not his fault. He was available, he was ready, he was willing and able, and therefore you have to pay him. Now, I don't think that would happen here, would it? Don't think so. But we're doing English law. So that's what would happen in the UK. Hawkster and Dill, the tour guide whose contract was anticipatorily breached. So the student could sue immediately. Or they can go ahead with their part of the contract. Hawkster couldn't. I mean, you can't wander around your city saying, "And this is the Freedom Monument, and there's McDonald's, and this is the Irish bar." You can't do that if there's nobody to show. But if it is possible to go ahead with your performance, then you may choose to go ahead with your performance. And then at the end of the time for performing, you then turn around and sue the other company, the other party. And that's what happened in White and Carter Councils and McGregor. White and Carter Councils is an advertising agency. McGregor owns a garage, McGregor's Garage, service station. And White and Carter Advertising Agency had the opportunity to put their adverts, or advertising for their clients, on waste bins where you throw your rubbish, on waste bins around Newcastle, which is in the northeast of England. They were going to put adverts on these waste bins for 3 years. They had that opportunity, bought that license from the local council, and they said, "We have the exclusive ability to put adverts on these waste bins. Now all we have to do is find a client who wants to pay us to put their adverts on these waste bins." And they phoned up McGregor's Garage, and they phoned him up at 20 to 12 in the morning. They phoned him up, and McGregor was out. But his supervisor, his foreman, was there. The man left in charge whilst McGregor was out. And they phoned him up and said, "We are White and Carter Councils. We have the opportunity to put an advert for McGregor's Garage on waste bins in the centre of Newcastle for 3 years. It would cost you so much if you were interested. Are you interested? Shall we go ahead? And the supervisor said yes. At 12:10, McGregor comes back to the garage, and he said to his foreman, anything happened, any news? The foreman said, no, not really. Oh, yeah, we had a phone call about half an hour ago from some advertising agents who said they're going to put McGregor adverts on waste bins around the city centre for 3 years. And McGregor said, well, I hope you told them no. And the foreman said, oh, I told them yes. Yes, they could go ahead. So McGregor immediately phoned up and said, my foreman has made a mistake. I'm very sorry. We don't want to go ahead. And White and Carter Council said, well, we are going to go ahead. And they did. For 3 years, they advertised McGregor's garage on waste bins around Newcastle city centre. Rain and hail and snow and fog and all the bad weather, these adverts were going on the waste bins. And McGregor kept ringing up and saying, I'm not paying, I've told you no, I told you no before you even started. And they said, well, we'll still carry on. And at the end of 3 years, they sent their invoice. And he said, I'm not paying it, I told you no. And he went to court. And the court said, it's available to the innocent, the injured party, if they can. It's available for them either to sue immediately for loss of profit or to go ahead with their part of the contract and then claim the full amount. And that's what White and Carter did. They went ahead with their part of the contract and successfully sued McGregor. He had to pay. I don't know if that would happen here. Well, probably not. But we're doing English law. So, the innocent party, the injured party, in an anticipatory breach situation, they can either sue immediately, Hawkster de la Tour, or they can go ahead with their part of the contract and then sue and claim damages, which is White and Carter Council and McGregor, or they have a third possibility. And that is, instead of suing immediately, they can delay their action. They can delay it and hope that with the passage of time, they will be able to persuade the other party to change their mind and go ahead with the contract. So we've got 3 possible courses of action. But if they do choose to wait and hope they can persuade the other people to change their mind, circumstances may happen which then deprives them of their right to sue. And the case Avery and Bowden is an example of that, where they chose to wait, but then because of the changing circumstances in the area in which they were then not able to go ahead and sue. The contract became void before they took legal action. Avery and Bowden was a case which took place in 1854. And although dates are not important, the particular dates here do have a relevance. The ship arrived in Odessa on the Black Sea. And it was going to be loaded, and there was a contract for it to be loaded with a cargo called tallow. And tallow is a natural product made from hemp, which is itself a natural product. And they were going to be loaded with tallow. And they arrived in Odessa on the 26th of June, 1854. And the contract was that they were going to be loaded with tallow so that they could then leave on the 6th of July, 1854. But when they arrived, the local agent came rushing down to the quayside and said, "Go away for your own safety. Leave now. Things are not good here in Odessa, in the Crimea. Things are not good. The British are not liked. We don't want you. We don't like you. We don't want to trade with you. Leave now." And the captain took the decision and said, "No, what we'll do is we'll stay. And we'll hope to persuade the local people to load the ship with tallow." And he tried. But then on the 4th of July, 1854, war was declared against England, and then to go ahead with the contract would have been trading with the enemy. And trading with the enemy is void. You're not allowed to do it. So the captain lost the right to sue because he had delayed his action. If he had turned straight away, if he'd gone straight away, or any time before the declaration of war, then he would have kept the rights to sue and to claim damages. But he didn't. He chose to delay. His ship was captured, he was captured, all his crewmen were captured, and they lived for the period of the Crimean War. They lived as prisoners of war. So it was not a good decision. Not only did they lose their freedom, but they also lost the right to sue. To be able to achieve full compensation, the injured party must have been in a position to complete their obligation at the time the date was due to start, the contract was due to start. There's a case called the McAuliffeonCaliph, which is the name of the ship. This ship was chartered. It was going to be available to be taken out and chartered around the world to do some cargo delivery and whatever. And it was chartered with effect from, I'll make the date up, it was chartered with effect from the 10th of October. And it was the place where the charter was to begin was Hong Kong. In fact, the ship was in Haiphong, not Hong Kong. The ship, at the time anticipatory breach was given, the ship was in Haiphong. And the notice period said although it was to be chartered with effect from the 10th, the notice was given on the 1st of October. We do not want this ship after all. So the ship owners sued the charterers. And it was established that on the 1st of October, the ship was in Haiphong, and it takes more than 10 days to get from Haiphong to Hong Kong. So they were not in a position to be able themselves, they were not in a position to go ahead with the contract, and therefore they couldn't claim full damages. They themselves were not in a position to start, and could not have been in a position to start because of the time it would have taken to get from Haiphong to Hong Kong. So McAuliffeonCaliph. And then damages, page 32. 2 parts, remoteness and measurement. Do you remember in crime, I was talking about crime yesterday, do you remember the consequences of crime is that the criminal will be punished? Well, the consequences of breach of contract, the main remedy, the main consequence for a breach of contract is a payment of damages. And damages will always be awarded if damages is appropriate. Sometimes it's not appropriate. Sometimes you don't want money by way of payment of damages. Sometimes you want somebody to stop doing something, or equally to start doing something, and the money payment is not enough. But if money payment is enough, then damages will be awarded. This is the common law remedy. It is the major common law remedy. There are others, but it's the major one. And damages are not a punishment. They're never intended as punishment. It's not a criminal offence. It's a civil offence, and an award of damages is to compensate the innocent party, to compensate the injured party. So damages is a monetary award made with the intention of compensation. Remoteness and measurement at the top bullet point says the world of damages splits into these 2 subheadings, and the 5th bullet point says remoteness. So let's consider the problem, the concept of the remoteness of damage. Only awarded if the damage which is suffered, or the damage which you cause, could have been in the reasonable contemplation of the ordinary man at the time the contract was broken. Could you reasonably have foreseen that by you breaking a contract, or the injured party would suffer as a result. And if you can foresee it, then the damage is not too distant, it's not too remote, and therefore you'll have to compensate for this foreseeable damage. The loss suffered should arise either as a natural consequence of the breach, or the person making the breach, the breacher, was aware of the special circumstances of the injured party. I've got 3 cases to look at, and the first 2 are always quoted. If there's a question on damages, and you look at the answer, you will always find these first 2 cases. If a question on damages comes up, you must quote these cases. Hadley and Baxendale. Hadley and Baxendale concerns a windmill. Certainly in the language of one of you in the room, Malonius. Yeah? Yes? Am I right? Malonus? Malonus, okay. But I don't know the language, I don't know what it is here. What's a windmill here? Yes, of course it is, I should have known. So you know what it is. And a windmill, you know that the sails are pushed by the wind, so the sails go round, and that going round then drives the shaft, which turns a cog, and the cog then turns a vertical shaft, which then grinds the stone wheel. Yeah? That's how they work, basically. That's how they work. But of course, with all this movement, and historically the shafts, the drive shafts, are made of wood. And with all this movement, the wood will wear out. It will get worn away, and it will become maybe unsafe. If it gets too worn away, it can become unsafe. So it's normal practice, apparently, for windmill owners to keep a spare, so that when one drive shaft wears out, the windmill owner will take that drive shaft out, put a new one, the spare one, in its place, and give the old one to a carrier to take to a manufacturer who will make a new shaft. That then gets brought back, and that then becomes the spare. All right? It's common sense. Hadley didn't keep a spare. We don't know this. Well, you know it because I've just told you, but he didn't keep a spare. So he took the old shaft out and he gave it to a carrier and said, can you take this to the manufacturer, get a new one made and bring it back? And the carrier did, but the carrier delayed. He was 3 weeks longer than he should have been. He didn't immediately go to the manufacturer and wait and then bring a new one back. He waited 3 weeks longer than he should have done. And the mill owner's going mad because he can't work the mill. He can't turn the stone wheel to grind the corn. So the mill owner said, where have you been? He said, I'm sorry I'm late, but things happened. And I called in somewhere else on the way. And the windmill owner said, I'm going to sue you for 3 weeks' worth of lost profits. It was the carrier's fault. He shouldn't have delayed. So who won that one? Jana. Who won that one? Did the windmill owner successfully sue the carrier, or was the carrier successful in his defense? Come on, I'll not shout at you if you get it wrong. I might do, but... Madara? Oh, chocolate? Are you eating chocolate? We've had a case of chocolate this morning, or yesterday. What was the chocolate case? Yeah, Nestle will do. That will do, you know. Incidentally, just let me say that. If you can only remember one of the parties' names, that's enough. In the case concerning Nestle. And even if you can't remember Nestle, in the case concerning chocolate bars, or the case concerning sweetie wrappings, that's all you need. You don't need the names. Wonderful if you can remember them, but if you can't, it's not the end of the world. Okay, who won this case? The windmill case. Come on, Sandra, you can do this. Guess, it's a 50-50 chance.
Okay, windmiller.
The windmill owner won, says Sandra. We need to go to Court of Appeal, because that's wrong. No, the carrier won. Remember, we're looking at remoteness. We're seeing, could the carrier reasonably have foreseen that by his delay, the windmill would not be able to work for 3 weeks? And the answer is no. It's normal business practice for the windmill owners to keep a spare, and therefore the carrier had every expectation that there should have been a spare there. So the carrier won that one. He successfully defended it. It could not have been reasonably foreseen in the reasonable contemplation of the ordinary man. That's Hadley Baxendale. Victoria Laundry and Newman Industries. Where did we have Victoria before? We had Victoria yesterday. Where did we have Victoria yesterday? Not the pier. No, not the pier. That was in Victorian times that people used to go along the... All right, okay. In Victorian times, people would walk along the pier and then they'd walk back again. No, that was not the... Victoria was actually in the name of a case. Anyone? Yes, Ramsgate Victoria Hotel and Montefiore was the case. Ramsgate Victoria Hotel. When I'm walking back to the apartment here, I walk down Elizabethus, and there's a building on Elizabethus. If you look at the top, there's a carving, and I don't know what it says, but the word Victoria is actually there. Spelt in the English way, not spelt your local way. So next time you happen to be walking down Elizabethus, be careful, because don't look up there all the time, because you'll bump into things. But every now and then, just stop and look up, and you'll see Victoria's written there. Isn't that fascinating? Yeah. Yes is the answer you're looking for, Benita. Victoria Laundry and Newman Industries. Oh, we had a laundry is a cleaning company. We had a cleaning company just before break. What was the cleaning company case? And what are those little things called? Little circular discs of metal which glitter in the glowing light at the nightclub. You can't, well, you could write that in the exam if you wish. What are they called? Sequins. Sequins. All right, well, this is a different laundry company. This is the Victoria Laundry and Newman Industries. Newman Industries are boiler manufacturers. They manufacture boilers, water heaters. And Victoria Laundry had got an order for a new boiler. It was to be installed and ready for use on the 31st of March. But it wasn't. It was only installed and ready for use by the 30th of June, 3 months. So they sued the laundry sued the boiler company, and they claimed for damages in respect of 3 months' worth of lost profits. And during that 3 months, they had been unable to bid, and they thought they were going to be successful if they had bid. They had been unable to bid and win a particularly profitable contract. And the word which is always used, and you'll find it used in the exam, is the word lucrative. A very profitable, lucrative, very profitable contract. And they were unable to bid for this lucrative contract. So they sued Newman Industries, claiming these lost profits, 3 months lost profits, and the profit that they would have gained if they had won this lucrative contract. Who won that one? Let me give you a clue here. You cannot be wrong. Whatever answer you give me, you cannot be wrong. Who? The laundry, yeah, but also the boiler company. They both won. The lucrative was not foreseeable. It was beyond the reasonable contemplation of the ordinary man. So the boiler company did not have to pay for this lucrative loss, but they did have to pay for the 3 months ordinary loss. So the laundry company won the 3-month claim, but they didn't win the lucrative claim. And then finally, Heron 2. What do you think Heron 2 is? It's a ship. Yeah, it's a ship. A heron is also a bird. It's a type of bird, a heron. It's a long-legged, tall bird with a long beak, and it catches fish and frogs. And it's a little bit like the national bird from your next-door neighbours down the road, a bird called gandras. Well, gandras is a stork. A stork. Well, it's a bit like a stork. They are different. Yeah? Have you decided what a heron is?
We have 3 options.
You have 3 options. Male herons, female herons, and dead herons. It's a grey colour. Well, we came across grey, didn't we? Where did we come across grey? Just a minute. Where did we come across grey? What's the name of a male swan? Graucob, yeah. And what was the strange name of the plaintiff? What was the strange, less strange and grand? Oh, look at these cases that you're remembering. Whoa. Sorry, what were you saying, Eddie?
The similar bird is a crane.
The similar bird is a crane, yeah. Oh, we came across crane yesterday as well, didn't we? Yeah, we did. The machinery called a crane, which lifts things and moves them around. What case was that? This big machine with a crane driver, and what was that about? Tell me again? Subcontractors and liability of the employer for the employee's negligence. What was that strange word I wrote on the screen that said your employer is liable for your actions? Yeah, a priest, a type of priest in the UK, a sort of junior priest, is called a vicar. He's a sort of local churchman. And if he owes a lot of money, when we owe money, we'll often write a document. And the document is what's called an IOU. And an IOU is the accepted abbreviation for I, O, U. And if the vicar has written a number of these debt documents, then you could say they are vicar IOUs, which then gives you the word vicarious, which means an employer is liable for the negligent acts of the employee committed in the course of the employee's business. Heron 2. Heron 2 is about a ship sailing to Basra. Iraq? Basra, Iraq or Iran? I can never get the two sorted out. Iraq. Iran? Iraq? Ireland? No, not Ireland. It's sailing there anyway. It's sailing to either Iraq or Iran, and I can't remember which. Basra. And it's loaded with, so it's to be loaded with sugar. No, it is loaded with sugar. It's loaded with sugar. The sugar is going to be sold when it gets there. But the captain delayed or went slowly or was 3 weeks later than he should have been. And in that 3-week period, the price of sugar fell. So that when the sugar did arrive in Basra, the amount for which it could be sold was substantially less than if he hadn't delayed. So the sugar owner sued him and said, by your delay, you have cost me all this profit. Should it have been in the reasonable contemplation of the ordinary person to realize that the price of sugar was a volatile matter and it can go up as well as down, and that by that delay there was a risk that the sugar price would fall? Yes, it should. It should have been in his reasonable contemplation. So the captain or the ship owner had to compensate the sugar owner. Now this is an interesting hypothetical question. What would have been the situation if during that 3-week period the price of sugar had gone up? Could the captain have then claimed the movement in that 3-week period as his own bonus? No. So the captain is on a no-win situation.